And we call 14-19966. The state of Texas versus Calvin Gary Walker. I believe that's the appropriate cause number. There are some other matters pending, but everybody agree that's the right cause number, isn't it? That we have the conviction.
What number? 14-19996?
How many nines did you throw in there?
Three, right?
No, it's only two. 19966.
Okay. All right.
But that's 66 is the final numbers.
All right.
Okay. There is something that I'm looking at for the first time, dated November 21st. Something called bankruptcy matters. Look at this just for a second, please. Thank you. Who wants to go first on this? The issues that the court wants to address. Everybody sound in, please. We have a court order dated November 6th, 2019. So it's 5 years and a couple of months into this order, which was a probation order where the defendant elected to have a trial by jury, was found guilty and sentenced to 10 years in prison. That was suspended. He was placed on regular probation for 10 years, ordered to pay a $10,000 fine. Restitution was to be determined, and restitution was later ordered was it approximately $1,172,000 was the restitution. Then there was a fine of $10,000, and then supervisory fees or with probation are $60 a month. The probation office is here, and I would like the probation office just to give me an update on the status. We can work from there on where we are, and it's all financial. So who is it with?
Yes, sir. Mr. Walker.
Ms. Hunter.
Continues to report as directed.
Come on up. I can't hear. Thank you.
Mr. Walker continues to report as directed. He still continues to report Social Security as his only means of support besides support from family and friends. And as of today, $828 has been paid towards restitution.
For 5 years, since we've been in this 5 years.
Just to correct, I think there was an appeal that went after the trial, and I think he's been on probation since October of 22. Is that right?
That's correct.
2.5 years.
2.5 years.
Okay.
Well, bad.
The probation order was signed on November 16th of 2019.
Yes, sir. But he did
That
appeal
when
it.
when the court rendered sentence based upon the jury verdict, and then that was all held in abeyance while the defendant appealed, which takes a long time. So we're talking about, what was the date you said?
October 10th of 22. I believe that's correct. Mr. DeGarren's welcome to correct me. Correct.
Okay, so we're 2 years and 3 months. 27 months into this, and how much What's the bottom line? What do we have net received from the defendant
Net received,
total? And then we'll work from, because it was primarily going to go to restitution, correct? That's what the court had expressed. And but there's some other fees that the state just rolls into a judgment that,
total credit, $2,488.
I'm sorry, say that again.
The total credit
Yes, ma'am.
paid in $2,488.
2,488.
Yes, sir, $88. $60 per month goes to the supervision fees, and whatever else is paid goes straight to restitution.
Oh, okay. Okay, so and what is restitution balance now?
$1,178,828.01.
Okay, the figure being the defendant on active probation, well, from the finalization of appeals, 27 months, and at $202,488 being totally paid, that averages $92 a month. And when supervisory fees are paid, that's a grand total of $32 going toward restitution, which would take him about 1,000 years to pay this off. Does everybody see the math doesn't work? About $384 are paid a year toward restitution. Which at $1,171,828 total, he could pay it off at this rate in 36,000 years. So that's not working. So but I look what is being presented to this court on financial is, according to the defense presentations and the probation, is that it's very limited on what he receives from what little amount he claims he earns. Most of the monies are that his income is based upon is from family and friends.
May we weigh in?
Unless, yeah, you're going to be able to articulate anything that this court can get more information on so that we can figure this out. Because this is an impossibility, but this court is going to know, Mr. DeGuerin, that we have a lot of people who are on probation who are paying restitution, and this Mr. Walker is sticking out as one of the very few who pays such a small amount. Why is that? Because the answer is, I don't want to hear about it. He has capabilities. He has earning power. I know it's limited with a felony conviction, but there are a lot of people who have felony convictions in this court who are paying monies, and it may not be $1 million, but they are paying substantially more than what Mr. Walker produces. And I'm not the one that follows him around to check on him to see, you're not working. I'm not going to do that. I can't do that. I'm going to have to rely on the probation office to do their job with the other thousands of cases that we're handling at the probation that we have to deal with. But if the state has some information that can help this court get to the bottom of this mystery of how this can get paid back under these circumstances, I'd like to know. So go ahead. Give it your best.
It is the state's position that the defendant has numerous properties and both personal and real properties that he was actually told to sell by the probation department, which was brought up in the hearing on October 23. If the court will recall, late last year, we became aware that he had filed bankruptcy, and the court was interested in knowing what happened with the bankruptcy. We have inquired in the bankruptcy hearing and the courts, and we have been informed that it was dismissed December 6th of this last year.
Why was it dismissed?
Because he wasn't paying the agreed on fees that he had.
So he's no longer in bankruptcy.
He's no longer in bankruptcy. However, inside the bankruptcy records, he filed a sworn affidavit about as to what properties he owned, and he listed all his properties. And we provided a copy to the defense, although I suspect they already had it. Of course, I provided a copy to the probation department this morning or this afternoon, and I'd like to provide a copy to the court.
Do you have this, Ms. Hunter?
I just gave her to her before we started.
Okay. Looking at this one for the first time.
Yes, sir. I've tabbed and it is signed under oath. It is signed. It was signed by electronic signature, and under the penalty of perjury in the federal courts. I understand they take that seriously.
Okay. First of all, Mr. DeGuerin, does Mr. Walker have real properties that he owns?
My understanding is that they're jointly owned between him and his wife, and he can't sell.
Why can't he? I mean, why can't he divest himself of his share, his portion of the ownership? Because just a joint partnership doesn't exclude somebody from being responsible for that portion of the monies, and unless it's a homestead, and I don't think you can claim more than one.
Under the documents he filed, he did not make such a claim. I wish to add that the information that's contained within his sworn, affidavits or statements to the bankruptcy court are in direct conflict with what he was telling your probation officer. The total amount of assets that he's claimed to have at that particular $996,000, of which non-exempt was $485,000, which could have been liquidated immediately, which included real property, numerous properties, numerous vehicles, numerous work vehicles, and all these things that he tried to use to allow himself to be in bankruptcy, which he did not inform this court, despite the court repeatedly requesting that he provide this information, because it's all designed for him not to pay the restitution in this court. And from the state's perspective, we've had enough. And we feel maybe it's time that we file an MTRP and we litigate this, him not paying his restitution, because we do believe he has the ability to pay it. At least make a good faith effort. Right now, the amount that he's paid is a mockery of this system.
Judge, may I add?
Yes, ma'am.
I did ask Mr. Walker for a copy of the bankruptcy hearing, and I did not receive it until I just received it from the DA. He did not provide a copy of it.
When did you ask for it?
In December.
What took so long? What took so long this lady works for me and she speaks on my behalf when we need information. What took so long?
You told them last hearing, I want all the information is being provided for the bankruptcy purpose that we don't have, so that Ms. Hunter can get that to me. We need to know all sources of income, sir. You said that directly to these two last hearing.
What about that? What about that from the defense?
Seeing some of this for the first time, but it looks like on January the 21st, Mr. Walker provided the probation officer.
What was the date that I ordered that, please?
November 15th of 24.
Think you got around to it timely?
You have to collect the document.
You think you really? I know finances. I got finances. I got to deal with it. But this is a court order. It took you 2 months. Is something more important than this?
Are you speaking to me?
Both of you. Yeah, I'd like to know because some of the court's orders or seem to be lackadaisically followed or not followed at all. I wanted that. Well, I thought that would be timely, but now we're 3 months past that date. And I'm just finding out about it. Shouldn't I be concerned? Go ahead.
If we look at the documents, those are two different documents. The one that I forwarded to you is different from the one that I received from Mr. Pat today.
In what way?
The first one that I received from Mr. Walker is from 2023, but I received the results from Mr. Pat today. So it's two different.
Okay, well, I want whatever's updated. I mean, things may change over time. I just wanted updated amounts. But what don't you have from him right now, Ms. Hunter?
Well, I received the bankruptcy info from Mr. Pat and he emailed the letters of support. Mr. Walker emailed the letters of support to me this morning, but I have been asking for those letters since December.
Since December?
Yes.
That's 2 months. Those things need to get in there as soon as possible, but you have this bankruptcy matter. It looks like y'all dealt with that thoroughly. When was all that filed? These documents that the state has given to me, when was that material filed in the bankruptcy court?
I don't know when it was exactly filed. He signed it according to this on December 1st of 23. So the information that provided all this.
Yeah, it's over
property-
a year ago.
Yes, sir.
I'm looking at what has been given to me on this bankruptcy, and this is executed on 12/1/23 by the defendant. And describe each residence, building, land, or other real estate you own or have an interest in, beginning with an entity 1520 Park Street. Current value of entire property, $78,686. Current value of the portion you own, $78,686. Okay. So
What page is that?
that's on 12 of 15. What I have is two.
There's a number.
It's, I'm not going to be able to help you on that. It's because it says page 1, schedule A/B property on a form 106A/B. And it says this number is 12/15. The page before it is page 4. And so that doesn't help me. But then the next page, page 2, is property. Lafitte Landing, Phase 2, Track 31A, MLK property, Martin Luther King Drive. Current value, $92,074. Current value of the portion you own, $92,074. Okay, so you got that's 171,000 right there. Then 3710 Roland Road. Single family home, current value 357,000. Current value of the portion you own 357,096. Is that your homestead?
Yes.
Next, 4445 Brandon Street. Current value 19,406. Current value of the portion you own 19,406. Langham Street. Current value of entire property $2,034. Current value of the portion you own $2,034. So total entries, dollar figure of the portion you own for your entries from part one, right at $550,000. And all but one of those is a homestead. So why are those properties being liquidated in some way to satisfy the restitution under the order the court ordered? Why is the defendant sitting on those properties and not doing whatever it takes to liquidate them? Anybody from the defense? You want to say something? And in vehicles, there's 3 vehicles and something else that isn't described under the 4th entry. Under watercraft, aircraft, motorhomes, ATVs, or other recreation or other vehicles of some kind. And you've got $30,000 that is the current value of the portion you own of a GMC Denali. $20,000 in a Jeep. $10,000 in a Cadillac Escalade. And then $20,000 in an unnamed entity that is number 4 that is not described, strangely enough. But it totals in your report to the bankruptcy of your vehicles. It's including 4, 3 being identified, 1 unidentified, with a total of $80,000. Well, those are liquidatable. Those are all of that is not exempt from this, from liquidation to pay toward the court ordered restitution. Once again, I don't understand why that's not being done. And then personal items is itemized with an approximate value of 9,000. And business related property. The value that you claim of the portion you own is $357,000. And that must be tools of your trade.
Page 12, Your Honor. You go a few more pages forward, there's a continuation.
Okay. Total real estate, $549,000 total. And personal property total, $446,000. The total is almost $1 million worth of value. And it's the defense contention that this long from the court order that $2,488 is all that's been paid total, when you have almost $1 million in property, many items, much of which is not exempt and has been reported to the bankruptcy court. Anything the state wants to add?
You know, you have repeatedly, and along with the probation department, has repeatedly requested this defendant to be honest and forthright about his finances, and he hasn't at any point of this whole situation. And he has at least $500,000 in assets that are non-exempt that were able to be applied to this restitution immediately. And he chose specifically, he had the ability to pay, and he did not. And trust me, there's more.
Well, even Mr. Walker, to the bankruptcy court, correct me if I'm wrong, but non-exempt assets that he owns equals almost $500,000, $485,000. Why isn't that being liquidated to pay the restitution for the children of the Beaumont Independent School District who are the beneficiaries of the court order in this case? Nothing, just crickets.
The probation office has asked Mr. Walker to liquidate his assets, and he declined.
He declines. Why?
I'm sorry, I didn't hear that.
She says that on behalf of the probation office, they have asked him to liquidate his assets to pay toward this restitution, and that he refuses to. I wanted to give him a fair opportunity, but we're talking about years now. Nothing. $2,000. He's sitting on $1 million. But he even admits $500,000 is non-exempt. That needs to be accomplished. I expect that to be accomplished immediate, if not yesterday. Or do we ask for a motion to revoke probation to be filed?
I'm seeing these for the first time,
Yes, sir.
and I don't see,
Well, I'm just looking at it, and unless those have disappeared some miraculous way, those are liquidatable, or he even claims under oath to the federal government that they're not exempt, and that needs to be paid to the Beaumont Independent School District, and it should have been done a long time ago. But the fact that $2,488 is all that's been paid is humiliating. It's an insult to the court's order, but it's an insult to the beneficiaries of the court's order and the restitution, which are the children of the Beaumont Independent School District, who are the primary beneficiaries. How fast can you get this accomplished?
well, I don't know.
I'm asking, y'all would be the ones. You're the one that's going to do it, or I'm going to order it to be
Well, I know
sold.
that, well, if these are correct values,
Well, he swore under oath they were.
I don't see that.
This is
signed anywhere by him.
this is, and now, this is what he provided to the United States Bankruptcy Court. I was in federal government long enough to know you don't provide anything to the federal government without being held accountable, even if you don't swear it's true. A false statement is a separate crime. I believe it's USC 1001. 18 USC 1001, a false statement in a proceeding to the federal government is
Yes,
Where's this?
actionable.
that's its electronic signature.
No,
No, it is. Or go ahead and revoke it and we'll see where that goes.
Oh, no, let's,
I see a place for a signature, but I don't see a signature. I don't know the answer to this.
Yes, sir.
Judge. I'm not a bankruptcy lawyer. He had a very good bankruptcy lawyer. All this property was
But you're-
subject to the bankruptcy.
I know, but you're
court.
representing for this, and I want I want you to find out. So you know, you can pass on your thoughts to me on his behalf, but I don't like what I see here. And this is disturbing. It's an affront to the orders of the court. And if it is not changed, we'll have a hearing and then the court makes a ruling on it. But I can assure you what I'm looking at in these documents that the state has tendered to the court and that my representatives have. It's appalling that only $2,488 when 400 and almost $500,000 of non-exempt the defendant has been enjoying and using in defiance of the court order. That's the way it appears to me. But why didn't y'all know? Why I'm finding out about this, and I just was handed this and I just looked at it. I mean, it says that we got a problem here. The math isn't adding up to what you can liquidate. I expect, and it's inferred, whatever is liquidatable, not exempt assets, are expected to be turned over to the restitution and paid toward the restitution this court ordered years ago. And that $92 per month has been paid is an affront. I mean, that's more than disturbing. It's humiliating.
The state's position is that we're past that. He's been lying to the court. Apparently he's lied to his lawyer or hidden that information from a lawyer. He's had the liquid assets and he's chosen not to pay the court or pay the restitution. I mean, this is not the only thing, Judge. I mean, when he was serving time in your upfront jail, he spent cash at the jail for his own personal benefit. Over $800 on watching movies while he's doing weekends. Over $2,200 on phone calls. Over $5,000 on getting blankets and chips and cookies while he's serving the weekends in jail. All that money was used for his personal benefit and could have been used to pay for restitution.
What else, Mr. DeGarren?
I'm not prepared to answer.
All right, what I'm going to do is ask that a motion to revoke probation be prepared and will be filed, and I can't act on that immediately. You have a fair opportunity for a hearing, but it would seem to me to be the most logical thing that people would, you, Mr. Walker, would be working tirelessly as quickly as humanly possible to ensure that all possible liquidatable assets that are non-exempt have been turned over or liquidated and put into the probation office coffers to be paid directly to the restitution. That would be sensible advice. But if it's not done by the time we get to the processing of this motion to revoke probation, we'll have a hearing. And then this court just wants those people to be paid like they're entitled to under due process that we use.
In spite of
But the fact that you're looking at 10 years in prison, if the court revoked your probation, would seem to be just normal inspiration to get this done and to not have worried about it because it's a court order. But no one has told me any reason why this documentation is wrong, especially in light of it's filed under your name in federal bankruptcy court. So I'm presuming that it's accurate. Does everybody understand where we are? A motion was going to be filed, and I'm going to set it for a hearing soon. And that gives you, I guess, that period of time to do what should have been done years ago. But that's not for me. I will move forward and we'll have a hearing and we'll make the determinations and findings. And it just is disappointing when the math here in a federal court filing shows that your monthly payments of $92 are insultingly and woefully inadequate and don't add up. I expect you to pay what you can. And it shows that you have almost $1 million of value, of which almost $500,000 are non-exempt, which can be liquidated. Those documents say it. And we'll have a hearing on it, and if that's what's necessary. But we're moving forward on the motion to revoke probation, and y'all got some time to see if you can prevent that from a final order of revocation by paying. Okay. Anything else? I'll get with everybody on a hearing setting after the motion is filed and then let everybody know. But I would hope, Mr. Walker, you would act tirelessly with your attorney and also make sure that your attorney understands, because I got a feeling he's a little surprised too. But I know Mr. Guerin, and I've always thought the highest of him, and he's always highly professional, gentleman all the way around. I get the sense that he needs to look at this thoroughly to help you, but this doesn't look good, and we're not going to tolerate. Some people can't pay, yeah, honestly, but you got to be accurate and forthright, and this doesn't look right. The math doesn't happen, but you have some. You're expected to turn that property into a liquidation toward this restitution order, if it's by law liquidatable and it is not exempt. This is the first time I've seen this, and I can read a financial statement. But I will be the determiner at the end on a motion to revoke probation. I'll decide on preponderance of the evidence where it falls. Everybody gets a chance to be heard. We're not just talking about a judgment of money. We're talking about 10 years in prison. Anything else? State?
No, Your Honor.
Defense? All right, we're in recess.